Good morning. Welcome to the Policy Review Committee Subcommittee. That'll be reviewing two policies today. I'll go ahead and call the roll. Board Member Cole,
Good morning, everybody present.
Ms. Ellingson,
Present.
Ms. White.
Present.
We have a quorum for the subcommittee that was named. At this point, Board Member Cole, I'll go ahead and go. I'll let you kind of run the show from here if that's fine with everybody.
All right. Thank you very much, Dr. Roush. Thank you again, everybody, for being here this morning. Before you, as you well know, we have two policies that we'll be going through. Interestingly, I think one of the top policies, if you had the opportunity to read both of them, I wanted to start with 5230. I thought that the glance that I took at it, there was some clean addition amendment that we could make to it. There was some clarification brought by Dr. Roush, but I wanted to take on the top end of it, take any discussion on what you saw might be a hole or a gap. For me, initially looking at this, I saw that I felt like we needed to explain or break out the controls or designation for parenting. So for example, as agent responsible for the education of the children of this district, the board should require that, okay.
Hold it up for you, Board Member
I
Cole.
thank you. I was reading it from another thing, but thank you very much. The board shall require the school to be notified in advance of such absences by request of the student's parent. At this point, I felt initially that we should describe parenting, because by Ohio Revised Code, parenting is different based on either natural birth. Of course, the courts look at this as equal. They give both parents equal footing. So there you have parent right there, but there's residential parents, there's co-parents, and of course there's legal guardian. In my initial conversation with Dr. Roush, we have a definition. If you'd like to share that definition with the committee, Dr. Roush, there is a definition for parent that is pretty much all encapsulating, but I'd like you to at least share that with them first, if you can.
Certainly. Allow me. I'm going to go ahead and stop sharing this screen, and then I'm going to go ahead and go over here and share another screen, and it will be highlighted when you see it here.
So this whole natural, adoptive, or surrogate parents or the party designated by the courts as the legal guardian or custodian of a student.
So this is in our existing bylaws.
Correct. So we've unpacked this, but then I said, you know what, everybody doesn't read a definition, so to speak, when they're interpreting our policy, maybe in day-to-day practice. But I think parent is clear enough, but I felt like maybe we should include legal guardian in that language as well. I thought that that was very important to do. I just wanted to get your feedback and any additional that any of you might have had about this policy.
I think that my concern about the language, which I had mentioned at the last meeting when we had first looked at this, is to avoid a situation where somebody who's a parent but doesn't actually have legal custody has the ability to remove the child. So I think that keeping some definition in this section that's workable, that basically steers towards somebody who has legal custody over the child. I know it's a little awkward to use the term legal guardian, but I think that's actually the term that we're looking for here. And just a reminder too, I mean, the case that, the tragic case that sort of brought this to attention was that man who took his son out of school and murdered him in the middle of the day. Everybody at the school knew that was his dad, but he did not have legal custody.
Would it be custodial parent or legal guardian? Would that be kind of where do we need to define that here? Do we add this in this section right here?
So Ohio Revised Code 3109.041 discusses the parenting provisions, and it breaks out what shared parenting is. There's parts of the law too that explain what a residential parent is, what a co-parent is. All of them have legal designations and authorities. And I'm thinking, again, that's why I wanted to include this until I I talked with Dr. Roush, and he said, well, we have parent definitions spelled out. But I still feel like it's important to make those designations, all of them showing that there's legal custodial right on the part of a parent or a legal custodian, a legal guardian. But they're all legal distinctions that make them somewhat different. But I'm much like you. I'm on the same street of making sure that we spell that out and include that. We back it up even more again, Emily, with no student shall be released to anyone who has not authorized such custody by the parents. And maybe again, we say parent, residential parent, co-parent, or legal guardian. Maybe we repeat that again. But I agree with you. The intent is to ensure safety of the child and that the appropriate party has custody of that child once that child is released, and an appropriate accountability for that child's whereabout when we want to know about late arrival.
So would this definition suffice then? And I also look at Ms. White because I know she practices a little bit in this area of law. So
Yeah.
You just went mute.
oh, we lost you, Ms. White. You're muted.
Oh, okay.
You're muted again.
Yeah.
Okay, sorry. Yeah, so I'm currently representing children who were born addicted to opioids in that big mega class action. And so I've actually had to brief a lot on like what it means to be a legal guardian recently, even though this is a little bit outside of my ordinary practice. I think that co-parent is a little redundant here, and I like the idea just to have it as clean as possible, to always use the same language throughout. So I think it might make sense to actually replicate the language here that was in the other definition of parenting, which looked fine. But to also spell it out again and just say, for the purpose of this policy, the definition included in the other policy applies, which is, and then just cut and paste that in its entirety. Because for the purposes of people who might actually be reading and using this policy, it's going to be like, folks in the school office facing a person who's coming to take a child. So when they look at this, they should be able to find that definition really easily. I'm not sure co-parent has any meaning that would be important for us, because that's really like parents vis-a-vis each other. Each residential parent is going to have that care, custody, and control of the child.
So there's no distinction in that a residential parent, a co-parent situation could be one where it's whether it's court appointed or two parents are just not in shared domicile. I thought that co-parent piece falls under that designation. But
then again, you're still getting into a situation where a court has spelled out what that is. And you're right too. I mean, folks who parent and never have a court decide anything about the relationship, then you're just talking about mom if they haven't gotten married. So natural, adoptive, surrogate, or party designated to the courts.
Is that second sentence, both parents will be considered to have equal rights unless a court of law decrees otherwise?
Yeah.
And that is what the state of Ohio does. This is how it looks at it.
Yeah.
Okay. Everybody okay with that?
Yeah, although this grandparent stuff I think might be a little too much here, because here we're literally talking about picking up the kid from school, not like preparing an IEP or engaging in anything more intense there. But this does seem to, the first sentence though seems to be appropriate for the late arrival and dismissal part.
So you don't.
This is where I'll gingerly disagree, because we are much like many other school districts. I won't make us just unique, but we come from multi-generational homes where in a lot of different instances, and I'll use that opiate piece as a perfect example.
Oh, I'm representing a lot of grandparents, you know that. Yeah.
There you go. So just because, those children are either living with their grandparents, maybe mom or pop has some sort of other issue that makes them not necessarily the best caretaker, we can at least appropriate that authority to them if it's within legal right to do so, and that those grandparents have presented the right documents. I think it's something that we empower everybody who is a proper caretaker of a child to know that they have efficacy, they have voice in being able to do something, as you said, as simple as drop a child off late or pick them up from school early.
Yeah. But ultimately, that would be a parent's or the legal guardian signing off on and saying, okay, grandma can be the one who picks up and drops off, which the policy otherwise includes. This second sentence, though, it has it done through like a power of attorney, which is, I mean,
So this is a
that's,
specific section of the revised code related to these child caretaker authorization affidavits and the grandparent power of attorney, and I think that's why we've got it specifically identified here, because they are a little different and they are a
like the
specific
kinship
creature
care
of
stuff.
statute.
Yeah.
So I don't know, and this would be, I guess, a more of a legal question. If we define it here, this would seem to supersede an section. If we provide a specific definition for this policy, it would seem to supersede the other definition. And so then I don't want there to be any confusion or concern, I guess, that if someone does have a grandparent power of attorney or the child caretaker authorization affidavit, then they would not be considered a parent for purposes of this policy.
Yeah.
That would be my only concern. I know it's a little lengthy and a little wordy.
No,
Maybe there's a way we can put it in better, but
perhaps Mr. Barnes can give us some additional guidance on that. But I think the intent is clear, right? To ensure that a child is released and, cared for by the appropriate person when they're not in our care. And that wherever that authority is extended, that those parties involved know that they're part of that group. So if there's need for further guidance on that by Mr. Barnes or, any of our legal team, perhaps Misty, we could send that query to the administration.
Yes, and I will take a look at that.
Okay, thank you. We just run into a lot of situations, and I've actually gotten a couple of emails, and it's not something that happens frequently, but it does happen, where it's gotten as high as us with folks sending us emails about a particular parent not wanting another parent to pick that child up, when Ohio law clearly says that each parent is on equal footing unless otherwise identified by a court of law to not be that custodial parent for any number of reasons. And it just keeps us, the clearer we are on it, I think it keeps us out of the dark, and it keeps administration out of the dark on who to release a child to and who not to release a child to. We deal with this stuff often enough that it's come as far as the school board. We've gotten emails on it. And one I got maybe 2 or 3 weeks ago.
I try to do a little quick fix here where I simply made a reference then to the grandparents when subject to a power of attorney or caretaker authorization affidavit. Does that get us what we need with cleaning up the language a little bit?
Yeah, because you don't want anybody to just throw up their hands and say, fine, I'm just not going to take my kid to school on a day they got a doctor's appointment. Or, oops, we're a little bit late today, in for a dime, in for a dollar. Let's just.
And we'll run the board member call to make sure we're good. But do folks feel comfortable with that language up there then?
I feel fine, because the practice, here's the policy, but our practice as well is that, we're signing every year. Me and Mrs. Cole and any other parent in the district or parents in the district are signing forms about who we are, who can Uncle Fred or Auntie Nisa come and pick kids up. All of that's taken into account in the forms that you submit to your school every year. So what we have here is definitive, but how we practice it is also encapsulated as well, if I'm making any sense. But yeah, I'm cool with it. If Mr. Barnes is okay with it as well.
Yes, I just read it and it does look good to me.
Just one other thought here, just throwing this out there, just another way to sort of approach and solve the problem. Do we have any policy, or would we want to have a policy for what to do about people who should not be taking these kids out of school? Like a way to more formalize, here, here's an emergency process for somebody who might endanger this child. You know, get the court order, get whatever. I don't know if we have one of those currently, but rather than imposing solutions on a problem that may not need a solution, that might be a more direct way to go at the problem.
We have
Dr.
like
Rausch,
a-
I don't think we do. I don't think we have. such a policy.
No, I believe that we rely on court orders and such as far as who's able to, if you're on the list, and if there's and if you're a legal parent, unless we've been told or have a court order saying you don't get to take the student or have access to the student. I mean, that there's not a policy, I think, that goes the other way and says here are the people who cannot pick up versus here are the people who can pick up. This is I think how most policies read are more on this kind of, on the, everybody's assumed to be able to, here's most policies are written this way as opposed to the other.
But to Ms. White's case, I think it possibly merits us to consider that, to take a look at that and consider that.
We
These
certainly
aren't gonna-
could.
Yeah, they're not going to come up very often, but I mean, might literally be life or death, and it might be a situation that's changing kind of rapidly. So.
Yeah, and for a parent who could otherwise get responsible guidance, where do we have the ability to provide that? And sometimes that might even neutralize the situation. That might even de-escalate something. When a principal or some other person has the authority to deny a parent their child because of court order, whether that parent knows it or not. And one would imagine that they would know it. But if we gave proper guidance as to how to address that situation, I think that could be helpful. It's interesting. I'd like to look into it.
And I don't know all the various pieces of guidance that go out regarding how to handle those situations. I know that legal sometimes gets those calls, and I think that it's actually Ms. Lillis who gets a number of those calls, perhaps even more so than Mr. Barnes, although he can certainly correct me. We could certainly look at that as a policy or a guideline that could be put into place. I just want to make sure we don't miss anything. I want to make sure that if we're going to do it, that's something that you almost want to have a fairly exhaustive list of what those items are, so that I don't want to run into a situation where we do release somebody and it kind of falls in between the policies. So that's I just want to make sure we get it right.
Okay.
The situations you'd be talking about, though, are really domestic violence. So it might make sense to maybe get input from folks in our community about what a best practice might look like, or even if this is a problem at all.
Okay.
As long as it's been adjudicated by a court of law and or legislated by the Ohio Revised Code, and we're within the proper authorities, then yeah.
Yeah, I just want to point out, though, that like a guy has a child, he doesn't marry the mother, he does not have custody. He doesn't have it. No legal custody whatsoever until he goes to court and says he's got custody. Our black letter law says the mother of an unmarried mother of a child is the sole residential custodian. So that might come as a surprise to some men who have not put a ring on it and remain involved in their child's life. They do not have legal custody. There's not going to be a court order that says that, though. It's going to be the absence of a court order that means that he doesn't have that right. So
say that again now. I'm sorry.
Okay. A couple that has a child who are not married, under the law, the mother is the only person who has legal custody until a court orders otherwise. A man has no right to residential custody until a court order establishing parentage and establishing that has been issued. Now, the presumption if he goes to court will be of shared parenting, of course. But if he doesn't go to court, and he's not married to the mother and wasn't at the time the child was born, he does not have custody. Only the mother does.
So could we talk a little bit about how this looks in practice? So I do not have children in the district, and it was a long time ago that I was signing in and out of school. So I know the district utilizes, has a lot of things digitized now. It may not be like signing in and out your student, but how is it, can someone describe that living list that Mr.
Yes.
Cole, you mentioned before, that there are people who are explicitly allowed by those who have the authority to give it to pick up that student. I do definitely see the value in having a complementary list of those who are explicitly not permitted to, just because there are some of those very difficult situations in which someone who might, without checking, seem to that staff member to have the authority to do that, but also be treading into a dangerous situation. We know that possession of children is something that people who are in like domestic violence situations, that is a weapon. So I do see the value in that. But can you talk about what this looks like on a day-to-day basis?
Doc Roush, if you want to cut in, as I said at the top of it, you just clearly spelled it out. There are forms that families fill out on an annual basis that clearly establish who has the control of the custodial right, parentage entitlements to children, and those parents then allow for certain designees, whether it's a family member or a family friend, the right and authority to pick a child up or drop them off. That's listed on them along with their contacts. So it's the name, their phone number, their information is codified as well. And that is put into our system. And buildings enter this on a building for building basis.
And I don't have our form right in front of me, and I will state I would want to go back and double check, because I've been filling out a few forms myself between scouting and then my getting my daughter enrolled for school and things like that. I know that on some of those forms, there's actually a section where it says these people are not to pick up. These are the people that we're telling you are not to pick up. My student, my scout in that regard, and so it's a both and in those circumstances. I will double check to see if that's how our form is. Like I said, they start to blend together in my head, and without it right in front of me right this moment, I don't want to misspeak. So,
Dr. Klein would have full clarity on that. Doc Roush, she'd be the one.
Yeah, I'm going to text her really quickly and just see if we can get a quick answer.
Because we might even do this. We might even submit those forms directly through enrollment, if I'm not mistaken.
They're usually done, because we redo these every year at the school. They're done at enrollment, but they're also done then annually at the school, where you kind of fill out. I think it's a yellow card, if I'm remembering the color correct. And you and Ms. White probably can remember. I think it's yellow, where you fill it out, and it's got the list of here are the people who can pick up. Here's our contact info, kind of the emergency contact card.
But in practice, though, I mean, if your kid is going to and from school every day, like, you're never going to encounter this policy. But the situations where it comes up might be very tense, because when you go to the school, you've got to like show ID, sign in, they scan your ID, and then they print out a visitor card. And I can tell you, for some reason, I probably have to double check it myself. But my husband's ID doesn't. Every time we go in together, it spits him out and says he's not authorized, and then we have to go and fill out forms. So something's gone wrong on that end. But it really is that formal, and it is a little daunting too if you're undocumented or don't have your ID with you that day. And of course, this is only going to come up in situations where the student is either being dropped off because they're late, which is already kind of stressful, or that they're getting picked up early, which might mean that they're sick, that the child is sick, or that a family member is sick, or that an accident has happened at work or something like that. So, and then the person who's picking them up is probably going to be completely unfamiliar with this whole situation. So having a clear policy will be very important for whoever's at the front desk, who might even be a volunteer at the school. So yeah.
But we're good to go from this point. I know that we'll have a clarifying question on a few things.
I've got that question into Dr. Klein. I know the other issue that kind of precipitated the subcommittee was this final phrase here, which is the presentation of a photo, and I know that it was photo ID. We added our other identification. I think it went from shall to may. I know this precipitated some discussion, which is I think a large part of why we're here today as well. And so I don't want to lose sight of that. If anybody wants to I think Ms. Ellingson and Ms. White, I think both of you raised some concerns with this particular requirement, or and maybe we got it to a better place. I don't know. That's why I please let us know.
So was there a concern about whether we should have shall be required by anyone, including parents, authorized such custody?
Shall was one of the concerns, certainly. I think that the other was just around photo identification. And I'll let Ms. White or Ms. Ellingson kind of talk more on that, because I know they helped raise the concern about why that may be a challenge for some of our families.
Yeah, I mean, I just think that it's just a little too much. I like having may because that leaves room for discretion and good judgment of the folks who are at the school. And every school that I've been in has some sort of like sign in, so there's like a record of who that person was. But also leaving that discretion where a school official could require ID also seems important. And I like having it be photo or other identification, because while government issued unexpired photo ID can be hard to come by, I can come up with something. But it's a thorny issue. I don't know if there's any clear right answer here.
For me, or well, Kelsey, do you have any thoughts before I say anything?
My thoughts are the same. It's important that we provide other, that we not just require photo IDs. We know some parents just aren't going to have them, and it's to the student's benefit that regardless of their parent status, they're able to come and leave as they need to, just as every other student would be able to. So I think it's very important that we not just limit it to photo IDs. Some parents have fear even coming to school in the first place. So Emily, as you were mentioning, as someone, I mean this with love, but like as someone who can walk into a school building with a lot of privilege, for you to say even that it's stressful and it's a whole rigmarole, which not that it shouldn't be, means that we need to pay special attention to those who have additional barriers to even getting their kid out of school or in late. So I do have a couple other follow-up questions, but that's generally where I stand on this one. I think it's an important element of the policy.
Okay. For me, a guiding principle ultimately in the spirit of this particular policy and in the public works of what we do every day, the most high priority for me is child safety, safety of our students. I'm a parent of 2 children in the district. I'm a school board member. But you know what? I have to adhere to the same protocols, whether I hate it or appreciate it, whether it's comfortable or uncomfortable. If it ensures the safety of children, that's my guiding principle right there. So to that, I agree that presentation of a photo or other identification may be asked or requested. My question is to the administration, if we're going to keep with the language may, which I'm okay with, is there a possibility to ensure that at the top of the year or within a school year's time frame, we ask for parents or that particular guardian to take a photo in our system? What is the name of our system that you check into?
Lobby guard.
Say it again. Lobby guard.
Lobby guard.
Lobby guard. is there an opportunity to take a photo of folks then that is then kept for record along with the records of the student? Is there a way to do that? So then if that parent, to your case, Ms. White and Ms. Ellingson, if there's not the ability to produce government identification, because we are a safe zone, by the way, as a school district. ICE, we don't allow, as per our policy last year, we are a safe zone for students against this whole ICE situation and all of that. We declared that when Dr. Good was superintendent of Columbus City Schools. We had the opportunity to travel nationally and learn more about these issues and how we incorporate those best practices in CCS. All that aside, do we have the ability to capture photographs that way to ensure safety of a student? That's something that I think would be helpful to know, but I'm okay, for the sake of this conversation, I'm certainly okay with presentation of photo or other identification as may be required by anyone, including parents authorized such custody. I think the language is fine.
I just wanted to say, I just think that like taking pictures is just, I don't know if we can really guarantee the security of that information. And I just think that that's one other level that might make families feel a bit unsafe. And I think that every hurdle that somebody perceives here might be a day that they keep their kid out of school, even though they might have had a very short appointment or something else. Or maybe they're late and they just decide to not go that day rather than face rigmarole at 9:30 trying to get their kid in late.
I hear you on that. But again, my guiding principle, as you know, in my role, and most especially, again, just as a parent, I want to be very thoughtful in how I say it, because I don't want to seem as if I'm being insensitive or as if I'm not taking certain things into consideration, because it is important. But there are protocols to enrolling into a public school district and being afforded that education. And there's simple things. And even if you have the ability to enroll a child as an undocumented person, then there's still certain protocols that can be followed. And if we can assist you by taking your photo and assigning that in some way to your child's record, period, your child's record that's guarded by FERPA, might I add, federal law, then that should be okay. That should be good enough. That should be fine. Again, if there are any other legal or liability considerations to be made, then we can take that into consideration by taking that to the administration with Mr. Barnes. But there are protocols to a public education, and to me, they're just certain things that just are non-negotiable, period. And it's for the safety of that child.
Yeah, I just want to point out though, that with that photo ID thing, I mean, promises have been made by our government about data security, about the use of data. For instance, DACA applications, DREAMer applications, all of that information has been, used by ICE, even though promises were made that it wasn't.
They're a government agency. I don't know what our protocols are with that, but at the end of the day, we want to be fair to everybody and ensure safety of every child. And if it means that there are certain rules in place to ensure that you are who you say you are, and we are letting that child into your custody, then that's what it is. That's just what it is. I'm more than happy to include this language, but I am absolutely immovable on anything that puts the safety of a child into question. When folks go to Kroger, when folks go to Walmart, when folks go to Target, your information is already, you're on the grid in so many different ways you don't even realize, just by going to get groceries. just by going to get groceries. And that information, to my understanding, is not federally protected.
No, I fully appreciate that. Like, I'm representing consumers in the Equifax data breach, and I've testified before the State House on data security. And the short answer is no. In America, we do not have true data security. And once information is put together in a list, it could either be used by hackers illegally, or it could be used by government entities for purposes that it wasn't imagined. But I guess my question is, how does a photograph make a student safer? In whatever that goal is there another way that's maybe more secure and less intimidating that we could achieve the same goal? Because we don't do that now. On the issue of photographs in particular, I guess I would also want to see more input from stakeholder groups as well.
Appreciate it. But we are in consensus at this time that the language as stated, presentation of photo or other identification may be required of anyone, including parents, authorize such custody.
Yeah, I'm in complete agreement with that,
Right.
because I think it leaves room for discretion and good judgment.
Okay, wonderful.
Ms. Ellingson, did you still have a couple of questions?
I don't think I have questions. No, I mean, I agree that the language is good, but just I really do agree with you, Emily, about I mean, data security is a real problem. I guess what I would say is I think the district has the tools to come up with an innovative solution that keeps people safe and upholds access for some parents who currently may not either don't have it or may not feel that they can utilize it. Whether that's by printing your own IDs and not storing the information, but having a parent be able to come in and say, hey, this is me on like your card, your district printed card. But I do think it is important for the sake of equity, which is another conversation we're having parallel to this one, that for the student and for the parent, they be able to have this access to coming and going just like every other student and family in the district. But I agree with the language as written.
Thank you. All right, are we ready to move to the next policy?
I will go ahead and share screen on that policy then. Give me one moment.
Okay, and how much time do we have?
We still have another 50 minutes.
Okay, awesome. As Dr. Roush is pulling that up, policy 5200 is what we'll be discussing. This is the attendance and truancy. Now, interestingly, there were some amended, some recommended amendments made that I saw highlighted in green that seemed interesting and fine. I guess where I am on this policy specifically is the COVID piece, and where we are now as Columbus City Schools looking to expand our virtual learning universe and space, making accommodations for student learners that way. And this doesn't, this policy as written gives some account for that, but not enough. And what I mean by this is in the third paragraph, at the top in the top language of attendance and truancy, it says, attendance need not always be within the school facilities, but a student will be considered to be in attendance if present at any place where school is in session by authority of the board. Now, with that in mind, schools in session now in accordance to Columbus City Schools and also in accordance to the Ohio Department of Education. But how do we ensure that students who are in virtual learning space are accounted for in terms of attendance and participation? To me, I see the spirit of this policy as being focused as the guiding principles on attendance and participation. those are two guiding principles of this policy as I see it. I wanted to get you all's feedback on that. But if we're looking at this from a virtual space, well, how then do we effectively account for that with the proper interventions, and if necessary, punitive action? My aim, my goal is not to make it so for all those who are on the call or watching or listening, I'm not saying, you know, if you didn't do your 5 assignments, you're out of here. We're sending you to juvenile court. That's not what I'm saying. What I'm saying though is how do we assure teaching, instruction, and learning by students who are a part of our virtual universe, ensuring that they're either, and we're measuring that. We're able to monitor that. We're able to look at that and say, hey, you've missed 10 assignments. So we can't account for your actual learning hours. And this is where, Dr. Roush, I'll have you unpack this a little bit for those who may not understand. We are accounting for our instructional hours in this policy because that's how the Ohio Department of Education looks at us. They look at us from hourly instruction, hourly operations. This policy well accounts for that, but it doesn't if you're looking at expanding virtual capacity and participation in that. How do we look at attendance and what are the things that we can, what are the key indicators, the key performance indicators that we can look at that help us monitor a student's attendance via their participation in a virtual space? Again, this is not something that I think that we'll even remotely be able to settle today. This is just a question that I'd like to carry over to the administration, but I wanted your feedback on that. I just see that in the virtual space, there could be some other things that we build into this policy as consideration for attendance and participation on the part of students.
Could I ask a question? Do we have a sense yet of how many students do not have access to one of either the internet or a Chromebook? Because I just don't.
I don't have that information. I don't have that information. I'm sorry.
And in addition to that, do we have any sense of how many students are just disengaged with their instructors? Because I think that you have to have those two pieces of information before you can form a policy, because you don't know if the problem is that kids aren't doing it, or maybe it's a problem in the household, or I suspect that there's probably still a huge problem with access to Wi-Fi and access to computers. And in a time when we can't go to the public library and access it, that's a temporary but real problem. And I don't think that kids could possibly be punished for that.
Again, I use very specific terms. I'm very intentional about how I say stuff. So again, the first point that I want to look at, because we cited in here, interventions that can be, hey, you don't have a hotspot, let's get you one. Hey, you don't have a Chromebook, let's get you one. All right. When you have these resources and there's still no participation, to me, then that's how we look at this idea of habitual absenteeism or truancy, right? This kind of chronic situation. I think that's where we unpack that a little more and how we address that moving forward. But for the sake of this policy and how we incorporate virtual learners, I thought it was really important to figure out how we monitor and then put ourselves in position to provide through policy clear resources to mandate, hey, we need to intercede on this and provide the necessary resources for that student to be able to succeed. That's where we are. That's the spirit of where I'm trying to go with this.
I just think that at this point, you really just have to have more data. And I would suggest too that probably the people who know best why the learning is not happening if it's not are the families themselves. People probably have a pretty good sense of either they have to work and the child's unsupervised, or they don't have Wi-Fi, or they have a computer that's getting shared by 5 siblings and they don't all have time. It might be a problem of some classes are synchronous learning where you have to be logged into Zoom at a particular time. If you've got multiple kids and the times conflict, that could be a problem. I mean, without knowing what the specific problems are, and they're probably going to be like a dozen, it's really hard to come up with solutions. And I think that before you get to the required solution, you just have to know what the problem is.
My point and shared sentiment. Mhm. Kelsey, any thoughts?
You're muted. You're muted, Ms.
Yeah,
Ellenson.
yeah.
I'm flipping between windows and not doing a very good job. No, you're both saying very good things. Again, keeping in mind, I'm really excited to get to work on the equity policy.
Amen.
It is a question of how we ingrain equity in all of our policies. So I think you do that by, to Emily's point, having an understanding of what the actual problems are. But I think for this time too, it is important to just ensure that this reads in a way that provides flexibility given how different things are right now. Personally, I have a lot of opinions about, I was briefly at the Department of Education, and I know that our system forces districts to have a seat time based system. And that means that, yeah, the minutes that butts are in seats count. But that's not always the best way to measure learning. So in my opinion, something that provides for flexibility, that has more focus on the performance of that student, their engagement with the curriculum and teachers and their peers, is well worth transitioning to, COVID-19 or not. So I'm just supporting a lot of what you both are saying, and I would really love to learn more about how families are faring right now, given that they may have barriers to participating in education.
Thank you both for that. I think we're all on the same street with regards to that. There are just a lot of questions that are arisen, and how do we adapt this in a way that adjusts to our new reality, and understanding too that we go as we grow. We'll go as we grow into this, or vice versa. So thank you for that. Are there any other, as we look at what's here now? How are we, Dr. Rouse, if you'd like to walk us through the finer points, if you will, of where we've made amended language, where we've made additions, and get clarity on where we are in consistency to that.
Certainly. So essentially, this mirrors statute. House Bill 410 back in the 131st General Assembly made some major overhauls to how we handle attendance and how we handle truancy. Part of that was we had to get the information it had to be signed off by the juvenile court. Juvenile court has now signed this off. A couple other items have been subsequently amended, having to do with they changed the requirement for the warning letter to go out. They took out excused absences as well as unexcused absences. At one point it was both. They've since removed that, so that's a benefit. Because you could have a student who is perhaps chronically ill, but we had to send a letter by statute letting them know that their student had missed so many days. That has been since fixed by the General Assembly, but this mirrors statutory language, and this is what you have. I think that there were some concerns regarding kind of the tone or the tenor of the language, and so there was some discussion of whether or not this needed perhaps a preamble of sorts. Because again, the language that's here is what's in statute, and so well, we really can't go in and start changing what the statutory language is. We certainly might be able to find a preamble or a different way to lead into this particular policy.
I think your comments hark back to a small rant of mine at a previous meeting. That my comments were rooted in just the fact that if someone's not showing up to school, we need to first meet them with empathy and try to understand. And I guess I understand that a lot of this is pulled right from ORC. but gosh, I really hate that sentence. Yada, 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 adjudicated for being an unruly child and an habitual truant. We shouldn't call a child a truant. So if there's a way to have this read that we can speak to the behaviors that we have to report to ODE without reducing a student to that, that's one small tone change we can make. But I do still agree that a preamble would be helpful.
Point out it's too much. Where's that exact habitual truant on here for me? I know it says it several times, so.
Oh, it does. I was looking in, oh gosh, for me, it's on the second page, but it's under the district shall.
Student will be
report
considered
to-
habitually truant if student is of compulsory. You just moved it.
Right here.
It's the second paragraph. A student will be considered habitually truant. And again, habitual truancy is a behavior. If the student is of compulsory age and absent without a legitimate excuse for 30 or more consecutive hours, for 42 or more hours, and I got your picture thing in the way where I can't see.
In one school month, there's 72 or more hours in 1 year. That's lifted directly from the statute. So I understand that. And so,
Yeah. The part I was reading was, let's see here. Maybe it's easier if you go all the way to the end, there's that A through F, but just above that, there's a 1 through 4. I'm referring to number 3.
when a child of compulsory school age who has been adjudicated an unruly child for being an habitual truant violates the court order regarding that adjudication.
Is that not out of our hands because a court of law actually designated this or court ordered this?
I think what would be out of your hands is reporting it or not, because that's what is required of you. But the way you communicate in your policies that you have to report something, I think that language is entirely up to you.
So when a child of compulsory school age has been adjudicated, so the court decided that.
Yeah, that's the key word there.
Right, adjudicated an unruly child for being an habitual truant violates the court order regarding that adjudication.
Can we change, instead of an habitual truant, which you know, that's personalizing it, can we make it into an adverb and say a child who has been adjudicated habitually truant, for being habitually truant? So remove the and just.
Well, but the adjudication is that they're an unruly child. That's the
Yeah,
actual adjudication.
And adjudicated unruly child for being habitually truant. Because otherwise the habitual truant it's like almost like name calling. It's like putting a label on the child instead of identifying the behavior. So unfortunately the label here is unruly child, but at least for being habitually truant sounds less like name calling. But once again, I don't know if that language is mandatory from the legislation.
Adjudicated an unruly child for habitual.
For being,
I mean, that's how the adjudication in the juvenile court comes through, that they're an unruly child, and that's the reason why.
Right.
You know, you'd be adjudicated for being an unruly child for curfew violation as well.
We're clear on the adjudication
Status offense.
Where her issue is being an habitual truant.
Yeah, that's the
She's
part
seeing that as a unnecessary designation. So what was your language change idea?
Remove and turn habitual into habitually. So turn an adjective into an adverb, and then you're for being habitually truant.
Are you saying for habitual truancy?
For habitual truancy, yeah, that's right.
Yes.
So then it's just removing that just one.
I think that we can get
in violation of the court order regarding that adjudication. So adjudicated an unruly child for habitual truancy in violation of court orders or of a court order regarding that adjudication. So it should be in violation of the. Yeah.
When a child of compulsory school age who has been educated on rules of habitual truancy, we need to put a verb here now, is in violation. You need a verb there.
Okay.
Okay.
Could I ask you a question? Do we know, is any part of this policy currently either being enforced or has it been suspended by the fact that kids are attending virtually with COVID?
The state has issued guidance that all students are considered to be in attendance during this time period.
Yeah, we said
Came
that
down
at
from
the
the
top
state.
of the meeting too.
Okay.
We said that at the very top of this discussion.
Okay.
I apologize if I wasn't clear.
So all of this really, I mean, and again, if we'd like to create a preamble of sorts, I'm fine with that. And I would say let us as an administration come back and figure out and identify how we want to handle any online piece. But I'd like to get this put in place. We're following the statute right now, but we need to update our policy to reflect the statute. So so that right now we're pointing folks to statute or pointing folks to other directives. Our policy's a little out of date. I'd like to just get this updated to kind of reflect the current state of law. But I'm happy to do a preamble if folks feel that, I mean, and I go back to Ms. Ellingson, I know that was something important to her, and I'm happy to kind of note that. And I wish I'd started typing when you started talking, because what you were saying was really good. So if you want to try to go back in and pull that out again, I'm happy. I'm ready now.
Naturally, I can recall none of the exact words I said, but I'm happy to connect with you offline.
All right. Yes, I'm happy with the preamble language as well. Are there any other questions about any other parts of this that, for clarity's sake or for necessity of adjustment, amendment?
Are you all good if I work with Ms. Ellingson offline and get that preamble ready to go, and then bring that back to the full committee has to take a look at this anyway. But if you're all comfortable with that, I'm happy to work with her on that.
Sounds like a plan. Thank you for your volunteership, stepping up. So thank you, Kelsey.
Always.
One other piece, I'm sorry, but before we
Please.
one other piece that might want to be looked at is there are disability specific rules for an obligation that a school district has when a child does have to miss a lot of school because of a medical absence. There's a certain point where there's an obligation to provide an individualized education even outside the school. And so I don't have that perfect language off of the top of my head, but that might be a place to at least reference what that policy is, just so that we're not automatically going to truancy for a child who might be out of school due to a complex medical issue. And there are many times where a medical issue might come up for a student who otherwise didn't have a learning disability. So if somebody, like a student, developed cancer or some other illness that is a disability midway through the school year, they're probably not going to need an individualized education. So they're not going to have an IEP plan, but they would have a 504 plan or other adjustments to school. And so rather than treat that as a disciplinary problem on the back end, getting on top of that and putting that up front in this policy might be a good idea.
Thank you for that.
I can do a cross reference to that.
Because there is a part of this policy where something medical is mentioned. It's a little further down from where I'm looking now.
Yeah, there's other parts of the IDEA too that require that when any sort of discipline is being looked at, and I wonder if truancy might even qualify. Whenever anything is on the table that would be an absence of a certain amount of time, there has to be a manifestation meeting. In other words, to try to figure out whether the thing that is being punished is a manifestation of the child's disability. So just cross-referencing those things so that people don't go down a path of discipline unnecessarily, when actually it might be an obligation of the school to provide something, might be more productive.
Do you want actual language cross-referencing it, or do you want me to, and I'm going to minimize this here. You see there are cross references we can add up here. Do you want them here, or do you want them in the body?
I think they should be in the body underneath the main section, just to qualify all of that.
As A, B, C breakouts,
Okay.
or 1, 2, 3, 4 breakouts.
Yeah, because you would still be treating every student with a disability the same as a student who doesn't have a disability unless otherwise needed. So excessive absences, just
Correct.
because a student has a disability and they're gone a lot, that might still be appropriate to treat under this policy. But where it's a situation that they're absent because of their disability, then that's where the obligation would be triggered. So I think it would make sense to state the general rule first, and then just have something to be like a reminder to
Gotcha.
go check.
Yeah, there's a section, I agree with you. There's a section lower that speaks about the superintendent being able to waive. I'm paraphrasing, but if there's a way for the superintendent to actually waive under those special kinds of.
I guess where I'm trying to go with this though is it's not going to be waiving it. It's going to be an obligation to actually provide education outside the classroom. So it's not like kids in the hospital, they don't have to go to school. In fact, they might actually have to go to school, but the school might have to bring the education to them. So it's just putting that in mind when you're dealing with excessive absences, because that's where it would come up.
I got you. I wasn't talking about waiving the education. I was specifically speaking about what this policy is relative to in attendance and truancy.
Got it.
That's what I'm speaking to.
So for instance, for students who may be at Nationwide Children's Hospital, we actually pay educators that are at Nationwide Children's to provide educational services to the extent that we can't expect some student. Yeah, it's not like they're sitting in a class for 7 hours a day. It's going to be dependent upon what their health needs are. But yeah, we are providing educational services there at Nationwide. So I can do that cross-reference language, and then I will work with Ms. Ellingson on a preamble.
Awesome.
Sorry, I'm just. What is I meant this. Let's see here. Under reporting requirements, after the first paragraph after the bulleted, the numbered list, at the end of it, it's talking about unless the student has made substantial progress on the absence intervention plan. What would that look like in practice? Like, what would be in an absence intervention plan?
So, and this is going to vary from student to student. But an absence intervention plan could be, something that it could be. And again, I'm going to misspeak here. I know I am, and I probably shouldn't go down this road because I'm not an expert in what all are in those absence intervention plans.
Let's just see clarification, Dr. Roush. Again,
that's probably safer than me trying to go through into my head through anecdotal evidence on some of that. So,
yep. We'll get further information on that for you.
But those plans are those are constructed for the individual needs of that student, and part of that individual team is the parent of the student or the parent's designee, someone from the school, some employed by the district who has kind of a good relationship with that student, and then other people as needed. So you could maybe bring in school social workers, you could bring in other social service providers into that mix to try to identify what that student may need.
Mm-hmm.
So that's that macro level view of it, but I can get you more specifics.
Yeah. I guess I would love to see things like helping them get clean clothes to wear to school, or someone to walk with to school if they don't live in a safe neighborhood, or get a ride. So that's another opportunity for like empathy to manifest as action. And I think that's really important. Last thing, Dr. Roush, we can talk more about it offline if there is an appetite to do it here, but just another thing to spell out in this preamble is the why behind this. This policy reads as like the legal requirements around coming to school and what happens if you don't, but it doesn't really get into why these strategies are employed. It's to get them to come back, right? Because we understand that when kids come to school, they can learn and get closer to a path of flourishing. And it just, all the talk of the court action, although maybe it's necessary, I think it glosses over the fact that we're trying to get them to come back. That's that's an important part. So I hope we can discuss that more.
Too much stick, not enough carrot.
Certainly. Mr. Cole, any or other members of the committee, anything further on this?
I am fine.
Well, those are the only two items on the agenda for this subcommittee. So I will get with Ms. Ellingson and work on the preamble. I will work on the references that we mentioned earlier. Hopefully we can get together between now and next Thursday. If not, that's okay. I think that the policy review committee next Thursday is going to be jam-packed and busy enough. But Ms. Ellingson, if we can get together, that would certainly be helpful between now and then.
Of course.
I thank you both again for your time and your insights. This is always something incredible. I always enjoy doing real policy work where we're not only making some of these language changes, or actually looking at what this means now and to the future, and how we look at solving problems and addressing issues moving forward. So thank you so much for your feedback and your insight and your time. I hope all of you stay healthy and mask up, and we're all in this together.